I'm going to talk about personal grievances. So the word personal grievance is a term used in employment law, and what it really means is bringing a problem to the attention of an employer. That's it. There are different claims that can be the basis of a personal grievance, and I'll run through those now, and then I'm also going to talk about the time frame that you need to be aware of with raising a personal grievance. So claims that can be the basis of a personal grievance can be that an employee has been unjustifiably dismissed, that they've been subject to some kind of disadvantage, that they've been discriminated against, that they've been sexually harassed, that they've been treated adversely in their employment on the basis that they're affected by family violence, that they've been racially harassed, that they've been subject to duress in relation to their membership or non-membership in a union, that they've contravened different parts of the Employment Relations Act, that they've engaged in adverse conduct for a prohibited health and safety reason. And then finally, there's some parts that relate to the Protection of Whistleblowers Act. Now, these things can be quite technical, and what I encourage employers and employees to do is put the technical stuff aside, leave that to the lawyers, but if there's a problem in the workplace, then that's usually related to one or more claims that could be the basis of a personal grievance. Now, to raise a personal grievance, it can be done in writing or it can be done orally. Either way is fine. Of course, as lawyers, we tend to do it in writing. The most important thing to understand when raising a personal grievance is the time frame. An employee has 90 days to raise a personal grievance. Outside of that 90 days, it becomes very difficult and sometimes impossible. So when does this 90 days begin? The 90 days begin on the date that the action that's the basis for the personal grievance occurred or comes to the attention of the employee, whichever is later. Now, the 90-day time frame can be waived by consent, and that can also be implicit consent. And often what we see as lawyers is employers with the best of intentions engaging with an employee who raises a personal grievance outside of the 90 days, and because they've engaged with that employee, they've implicitly waived the 90-day requirement, and it harms their legal position later on. So as an employer or an employee, if you have any questions or concerns, reach out and seek advice early. We offer a free initial consultation, so pick up the phone and call us. Thanks for listening.